SJC-13101, Arnold Emma v. Massachusetts Parole Board.
Thank you. Attorney Cusack.
Good morning, Your Honors. May it please the court. Kelly Cusack on behalf of the petitioner, Arnold Emma. Arnold Emma is going to die. This court has the opportunity to decide whether he dies with dignity or he dies in prison. Mr. Emma is a convicted burglar who was granted medical parole because he was terminally ill and dying. His condition was that he was so debilitated, he did not pose a public safety risk when he was released. And at this point, no one is contesting, confined to a wheelchair in the MCI Shirley nursing unit, that he would ever burgle again. This court has to consider the gravity of the parole board's decision to revoke his medical parole is not the consequence to have him serve the remaining 4 years of his sentence. It is a consequence of sentencing him to death.
But counsel, can't the commissioner give him medical parole again right away?
That is a possibility. However, in practice, it does not seem that the statute so permits.
Right, but the parole statutes don't seem to permit the parole board to release somebody on medical parole. And Mr. Emma did violate parole, the medical parole conditions. And so he was appropriately brought back into the system. I don't see how we can rewrite the statutes to give the parole board the power that the commissioner has on medical parole.
It's not about the power to initially release someone on medical parole. And I think all of the parties have called this something different, including the amicus.
It's called reparole or whatever.
And I think that that is the wrong terminology to use here. The reparole does not appear in the medical parole statute or regulations. The only place that reparole appears is in the parole board's own regulations that were promulgated around discretionary parolees.
Right.
Reparole should be defined, as I state in my reply brief, at just what it sounds like. A person who has been granted a parole permit, goes through the revocation proceedings, is determined to have violated the parole, and then the parole board takes a discretionary second step, determining that that person should be reincarcerated, and then is granted a second parole after through a discretionary parole hearing.
I have another question for you, though. Oh, sorry, Justice Gaziano, go ahead. Is that you stated that the defendant had a liberty interest in this medical parole. Is that different than a regular parolee's liberty interest? Is there a difference in these liberty interests?
I would suggest that there isn't a difference in these liberty interests. There are two separate liberty interests, and I raise the statutory release liberty interest because this court still has under discretion Racine and Harmon. It hasn't yet been decided. But the main liberty interest that we're discussing is the one that comes from that conditional release. Upon a parolee or probationer's release, both federal and Massachusetts courts have held, there is a protected conditional liberty interest upon release. And that should be attained, and that the medical parolee should have a right to preserve that liberty
So
interest.
it's the same. That's all I wanted to know. It's the same. So you can take Justice Gaziano's question.
Can you explain to me further, because the statutory language is against you, but I understand you're making a due process argument. Can you explain to me why the person couldn't apply for medical parole anew?
I certainly think that someone could apply for medical parole anew, but I think that the court has to consider medical parolees are unique. These are individuals who are terminally ill, incapacitated, potentially suffer from dementia, have other cognitive limitations. To have someone who is going through those medical issues brought back into custody during a global pandemic, and then suggest that they should take that onerous burden of petitioning again.
The problem you have is that they've been granted medical parole, then they violated it, and then the parole board found a violation, correct?
They have found, well, I guess Your Honor's question was about whether and when they can start the petition for medical parole. So I think the statute, the way that it's written, and the way that the respondents previously under Harmon and Racine have taken, is that they don't have an opportunity to file a second petition after being denied. Now they're taking a contrary petition.
I apologize because I know the bottom line of Racine, but anyway. So your position is that the way it's interpreted by DOC, at least right now, is that there's no ability to serial refile.
They're taking a contrary position in this particular case and saying, yes, there is nothing to limit a second medical parole petition, but that's assuming that someone has already been revoked. So if you're looking at the timeline of these two statutes and requiring when they should actually file for a second medical parole petition, if you haven't been revoked yet and you're waiting for that decision, we're talking about 66 days or 60 days until the parole revocation decision, and then 66 days from there. 126 days for someone like Arnold Emma, whose prognosis as of February was 3 to 6 months, but he will likely succumb before then. It's just not fundamentally fair to put that process on him and have him file for another second medical parole petition. The issue before this court.
They don't find a violation the first time, though. So they exercise some flexibility here. They sort of give him a warning. Does that sort of suggest that they're using the violation, they're liberally interpreting violation to take into account what you're talking about, which is it doesn't really amount to a violation that justifies re-imprisoning?
No, I would disagree with Your Honor, and I think that part of that discretion that they're reading into that same section of the statute, if you read 119AF, the line prior says if a parole officer receives credible information that a prisoner has failed to comply by a condition, the parole officer shall immediately arrest.
But
And the
didn't
parole board takes the
they,
position-
they gave him a break though, right? He
They did.
did. So they have, I mean, we'll be asking your opposing counsel some of that, but they do seem to have some flexibility here. At least they've exercised some, whether they legally should have. Is it your view that they should have automatically violated him the first time?
No, my view is that the board is not applying the law as written and does read into it discretion, why would that discretion then not apply to the two-step Morrissey process
Well,
during
but I
the
guess the
revocation
question I have
proceeding?
is, are they really, without saying it, doing it? And by deciding that a violation is something that justifies re-imprisoning, they're doing what you're asking them to do anyway.
I would disagree with that. The graduated sanctions and warning tickets are discretionary, and they're supposed to be the least restrictive means possible at the time. But once you get to the revocation process, and once it commences, there is a two-step process under Morrissey that's required. First is that fact-finding process. Was there in fact a violation? And that doesn't happen with the graduated or warning ticket. That is, they have a case conference, they determine what the sanction should be, but at an actual revocation hearing, they have to determine whether or not there was an actual violation. Then the second step requires whether or not that violation should warrant reincarceration. And here, the parole board and the Department of Correction take the position that they lack that discretion for the second step, that it should only have discretion, it can only determine whether there's an actual violation. The proposal is this bifurcated hearing, which frankly is just completely unworkable. I think you have to consider, and I should...
So I understand your point, but how do we do it with the statutory language? That's what is it that it's a constitution, the statute's unconstitutional unless we read that in, or is there some way you read this flexibility into the statute? Because I have the same problem Justice Gaziano does, which is just the language is so explicit.
I would agree with Your Honor that the language says shall, and I think that the amicus brief filed by the prisoner legal services does point out a way that this court can interpret some discretion, and that this shall is really a directive, and it's not, and has the discretion. And
without playing with the language and being cute that way, can we just say that because parole is at play here, and there's a parole hearing, there's a due process overlay, and then apply the two-step Morrissey process?
Absolutely. I think there are a number of ways.
That doesn't require us to take a machete to the statute, correct?
I agree with Your Honor that Morrissey requires the two-step process along with the bare minimum procedural concepts. And the statute is clear that the decision to first release a medical parolee is by the commissioner. Every decision stemming from that release is to the parole board. The parole board monitors the home plan, sets the terms and conditions, can alter the terms and conditions, is scheduled to supervise and proceed over revocation
And just to
proceedings.
wrap up this thought, in what you're arguing, as I understand it, is that the ability to seek a subsequent medical parole is not a substitute for the second part of Morrissey.
That's correct. And I think the best way, and I phrase this in my reply brief, is this is really about the authority not to revoke, to make that decision to not end somebody's medical parole, take them out of their palliative care, away from their medical providers, and put them back in prison where they're likely going to die before they reach their actual parole eligibility or their sentence max date. And I would suggest to the court that Morrissey does allow for that discretion, and it actually requires it. The parole board own regulations and in the agreed statement of facts agree that once someone begins the revocation proceedings, it goes under the CMRs regarding revocation proceedings. And I would suggest that this needs to happen in the same proceeding. Morrissey requires not only this two-step process, but also that it happen in a reasonable amount of time. And as I've already pointed out, having this onerous burden on a medical parolee to start the clock over at some point, whether it's day one from the beginning of parole revocation proceedings or day 60, is just fundamentally unfair. Any day a prisoner who is eligible for medical parole remains in prison is unreasonable and unconstitutional. This bifurcated hearing that's proposed not only causes an unreasonable delay, but is wasteful and cumbersome. And as this court has held before in Dinkins, where it struck down the exception for any sentences to be held after consecutive life sentences, would be wasteful of the board's limited time and resources, creating additional burdens on those who are seeking parole. Here, those same issues would apply. If it is not the same fact finder simultaneously making that decision, we also leave open room for error, which is in fact, on this record, what happened with Mr. Emma. In the respondent's brief, they claim
Counsel,
that
can I ask you a question then? That it does seem to me that that's the really thrust of your argument, that it's not the same fact finder making the decision whether to parole again or revoke it. Where in Morrissey does it say it has to be the same fact finder?
It's not specifically explained in Morrissey that it has to constitutionally be the same fact finder as the decision maker.
Okay,
However,
so I guess I'm trying to figure out, given the statutory language, which I agree is clear, why the due process clause requires the same fact finder.
because there's this issue of unreasonable delay and the opportunity for error. And for medical parolees who you're taking off the street, who are the most vulnerable, the most infirm, the most that this court has found.
And what is
legislator
the
intended,
delay, again, required by statute?
The delay at the beginning of revocation proceedings.
What's the number? You're saying
60 days.
60 days. So
And
60 days is a constitutional violation.
60 days plus another 66. So if the medical parole petition.
So 126 days, if I do the
Correct.
math right, is a constitutional violation.
I would suggest yes on these facts, particularly on these facts where Arnold Emma has.
Where do you see that in Morrissey? 126 days is
There's
too
no
much.
specific number in Morrissey.
I know, but
They've
you're
raised the
reading that
reasonable.
into Morrissey. That seems to be the crux of your argument. What is that?
The crux of my argument is based on the facts of Mr. Emma's case, in that he had 3 to 6 months to live, and that diagnosis and prognosis came down in February. So if we're talking about 126 days, we're talking about potentially the end of his life before he has any finality or decision from the time that he's seeking re-release, or in my opinion, the authority for the parole board not to revoke.
So it's the coincidence of your particular client's illness and expected lifespan with the 126 days that constitutes the due process violation. I'm not suggesting it's not. I'm just trying to figure it out.
That, and there's this issue about the room for error. Because if you have the commissioner, it's clear on these facts that the commissioner has no influence, isn't present, doesn't have any part of the parole revocation proceedings. She's not there. She doesn't know what facts are presented. She's only given a record of decision, plus potentially a hearing summary, depending on whether it's the provisional or the final revocation. And on this record, you can see where there is room for error, because Mr. Emma, while his provisional revocation hearing, there was found on both counts for probable cause to hold him pending a final hearing. At his final hearing, the only violation that was affirmed was his failure to abide by his home plan, mainly because he was wheeled out of the Boston Medical Center and taken back into Department of Corrections custody. So the parole board in the respondent's brief now states that part of the reason and the violations were both that he absconded from parole and he was terminated from his home plan. That is not what actually happened at the hearing. It's clear in the transcripts. It's clear in the record that the only reason that the violation was affirmed was on the second ground, that he was terminated from his home care plan. So consider someone in Mr. Emma's position who now you have the decision maker relying on a mistake of fact. There's nothing in the statute or regulations that allow for any kind of remedy. And so reading those into Morrissey, the reasonableness and should also include that this fact-finding and the decision-making happen by the same body simultaneously, and that's what Morrissey should require.
Well, if the body made the wrong, you're saying that the board concluded something incorrectly?
Correct.
All right, so your solution to that is having the board decide whether or not to revoke?
And I'm sorry, I misheard you. The respondents in their brief before this court have stated that their position is that the two violations were affirmed. That is not correct on the record. And I don't know if that's coming from, it's a joint brief, so I don't know if that's coming from DOC or from the parole board. But there is room for error where the person who is the fact finder is not also the decision maker. And then there's left for medical parolees, the most infirm, vulnerable prisoners in Massachusetts, are left without any remedy to fix that error while they're also dying. The court should also consider, and I realize my time is up, that the legislature's intent should not have also thought about these minor, technical, non-willful violations. I think the court should consider hypothetical situations where you have someone who has dementia and fails and gets lost, or fails to meet with his supervising parole officer, or wanders out of his facility so many times that he gets terminated and has nowhere else to go. Or a situation where someone is subject to GPS monitoring and they need an ambulance for emergency care to a hospital. On the way, their batteries die. Is this what the legislature intended when they implemented and wrote this compassionate release statute, that those people violated their conditions and therefore they must resume their sentence?
Okay, I'm going to ask Attorney Johnston to respond to those points. So thank you.
Thank you, Your Honor. First, Your Honor, I would like to respond to my sister's contention that Mr. Emma was not revoked because of the violation for not agreeing to go back to the treatment center. I want to make clear that although the basis was a violation of his home plan, the entire discussion at the final revocation hearing, the violation of the home plan was refusing to go back to BMC treatment center. It was trying to abscond for treatment. That was the entire discussion at the final revocation hearing. My sister is trying to make a distinction that it's a distinction without a difference, essentially. The basis for the violation was the fact that he refused to go back to BMC for treatment. He admitted that. At the hearing himself, he admitted that. He stated that he wasn't happy with his placement. He should have consulted the parole board about that. That was clearly the basis for the board's determination of the violation. Whether we call it the absconding from treatment or we call it a violation of a home plan, that is why he was taken back into custody. That is why he was not allowed back at the Farron Center. There's really no question about that. And if this court looks at the transcripts from the final revocation hearing, this court will see that. Turning to the clear language of the medical parole statute, I think, and it's been noted by this court, based on the language of the medical parole statute, it is clear what the parole statute says, and I specifically refer this court to Chapter 127-119-AF, where it states that upon a finding of a violation, and assuming that this is a violation that warrants revocation.
Suppose we agree with you that the statute says what the statute says, right? What about the due process component of the statute? How is that satisfied?
Yes, Your Honor, and I don't think there is any issue here with the process that is set forth in the regulations, or I'm sorry, the statute and the regulations violating Morrissey versus Brewer. Morrissey versus Brewer provides for certain due process protections. The parole board absolutely agrees that the medical parolee is entitled to those. Those include, and they're listed in the brief, the right to a neutral body to hear, a notice of the hearing, a right to a neutral body, a right to cross-examine witnesses and present evidence, a right to be represented if they want, and a right to a notice of the reasons for the revocation.
But yeah, your opposing counsel suggests that Morrissey also holds that there needs to be this two-step process, and that two-step process is required by the Constitution, and that in this case, the second step is missing.
So, Your Honor, first of all, I think that it's far from clear from Morrissey that there has to be this two-step process. I think that, so what Morrissey says is that you need to they have the right to, first you look at whether or not there's a violation, and then yes, if there's any mitigating circumstance. But it would seem from Morrissey that mitigating circumstance goes to the violation itself. Now, the parole board's position here is certainly not that the parole board panel can't make a determination that it doesn't constitute a violation because, say, the person was under duress when this happened. What the parole board's position is that the parole board hearing panel cannot take into kind of extraneous or totality of the circumstances type determination where the parole board says, yes, he committed this violation. It's a violation that warrants revocation, but we still make a determination in our discretion that we don't think this person should be on medical parole.
The parole board's saying that any violation requires re-imprisoning, right? Any violation. So if they find, I mean, they exercised a little discretion by giving a warning for the first violation, but even that probably is contrary to your interpretation here, right?
No, Your Honor. So here I would say that once there's a violation that the parole board, it's up to the parole board to find if there's a violation that warrants revocation. Here they did so, and that was based on, in this case, based on the information, the evidence presented. Now, the parole board hearing members did say, if it was up to us, we would allow you to go forward on this new home plan. But that isn't a determination that there wasn't a violation that warranted revocation.
No, I understand, but the hard question in the case is there some kind of, procedural due process right for them to do the second step? That not only was there a violation, but did that violation rise to the level where it requires you to re-imprison? They're saying it does, because Morrissey at least talks about the two-step process. The
violation, whether or not, if it's a violation that warrants revocation, yes, the parole board does have to, at that point, the prisoner, according to the language of the statute, resume serving their sentence.
Right, but the legislature seems to have made a determination that every violation requires re-imprisoning. But the Supreme Court in Morrissey seems to think that the parole process itself has to have a second step to it, right?
Right, and I think Morrissey has to be looking at, Morrissey versus Brewer has to be taken in context, Your Honor. Morrissey versus Brewer is a 1972 Supreme Court case that is discussing traditional parole. It is not a situation where they're looking at a situation where the parole board is the one that grants that discretionary parole, and then they make that additional determination. They're not looking, Morrissey versus Brewer is not, this is prior to any medical parole statutes, it's prior to any compassionate release type statutes.
I get it.
So
the context here is much more confusing because you have two different entities involved in the decision to medically parole. But at the same time, if we look at all the context, your opposing counsel says, well, this guy's going to die. He's in the category of the terminally ill medical parolee, not the impaired medical parolee is no longer dangerous. And therefore, this 126-day process is going to end up with him basically dying no matter what.
Your Honor, and I definitely understand. So one point I want to make, and as this court has already pointed out, Morrissey versus Brewer itself does not say that one specific agency, that there's a due process requirement that one specific agency makes that determination in terms of that second step, as my sister calls it, of whether or not someone is entitled to be re-paroled or whatever term we use, released to the community if after a violation that warrants revocation. So Morrissey versus Brewer certainly doesn't say anything like that. And my sister would be reading something into Morrissey, or anybody would be reading something into Morrissey versus Brewer to claim that.
Right.
But in terms of
I agree with you on that point, but I think her better argument is that the 126-day process doesn't make any sense when we're dealing with terminally ill parolees. Meaning, I wouldn't say it doesn't make any sense, doesn't protect the due process rights properly of these prisoners, because they're going to die in that 126 days.
Right. I understand, Your Honor, absolutely. And so one thing this court has already pointed out, there's no time limit set in Morrissey versus Brewer, but I understand that there's a concern with 126 days. But what my sister is arguing that it's 126 days necessarily, but that's not actually the case. The petitioner does not have to wait until after the final revocation hearing, the prisoner to file a new petition. In fact, Mr. Emma in this case did not. I think he filed his petition in late January. The actual final revocation decision was decided on February 10th.
So your view is he could file, it's a 66 days because he could file for re-parole immediately?
Yes, Your Honor. I'm not sure that it will always be within the 66 days in a situation like this where, say, I could imagine the commissioner of the DOC, if there's a final revocation hearing happening, would want that decision of the parole board's final revocation hearing decision, because imagine if they did not end up finding that he violated. So I can imagine the commissioner wanting that decision in advance of making her own decision on a medical parole petition, but we're not necessarily looking at 126 days here. And Mr. Emma himself here filed a second medical parole petition before the final revocation hearing. So this idea that it's necessarily going to be 126 days, that just doesn't bear out, and there's nothing in the statute to support that reading. Also, I want to point out here that with respect to Mr. Emma's case, I want to point out that, and with respect to any medical parolee who has violated their medical parole, the parole board's determination will not necessarily be the same as the DOC commissioner's determination. And that bears out in the facts that were reported to this court about what happened, that the court asked a certain question: how many people violated parole, how many people were brought back and returned to custody and filed new petitions. And we reported to the court 6 people, 4 of those individuals for violating the parole. 3 of those people, including Emma, filed new petitions, and the DOC commissioner denied those new petitions. That just in itself shows that the DOC commissioner's determination may not be the same as the board, because she's taking into consideration certain factors at that time. And the fact that someone violated those conditions may change those factors. We don't just look to whether or not, the DOC commissioner doesn't just look to whether or not someone is terminally ill or permanently incapacitated. They look to see whether that person could live at liberty
Again, and I'm unlike some of my colleagues who put on conditions of parole sort of 30 times a day. I didn't, but there are all kinds of very specific violations out there. So basically we're just going to automatically put all these guys back in.
Absolutely not, Your Honor.
As long as it's intentional. I mean, I know you described one where your car breaks down and you don't make it to your parole officer, but if there's an intentional violation of any kind, you're out of luck and back in prison.
Absolutely not, Your Honor. And I think that
Where does the
and I think,
discretion
so
come?
I think we speak to that in our brief, in that even in Mr. Emma's case, and as this court has noted, first of all, the first stage is that a parole officer finds if there is a violation. Now, we refer also to the statute 127, 130, and we look at that and we see that the parole officer, in conjunction with the parole in consultation with the parole supervisor, makes a determination as to whether or not this is a violation that warrants revocation proceedings.
Well, hold on. That second part is not really true, right? Where is the warrants revocation? I thought any violation, the statute says just any violation results in revocation, not warrants revocation. There's no discretion built in. I know they kind of did some discretion here, but there isn't any built in, is there? Because then if that's the case, aren't they right? Shouldn't we just come right out and say it? If you're saying that they make a determination that it warrants revocation.
Not when it's a violation of their actual medical parole plan. So I think there is something different between a minor infraction of, say, what happened with Mr. Emma originally in November, of being rude to staff, and a violation of the actual person's medical parole plan. Here, this is his home plan. It's his actual treatment. The home plan is one of the considerations that the commissioner of the DOC takes into consideration when weighing the question of whether or not this person should be given medical parole.
But that's not in the statute, right?
No, but what?
So it just says any violation of probation, right? If there's a limitation, it would be helpful to know. Could you articulate what the limitation the Commonwealth says is in there? Because I don't really get it. I thought it was automatic.
So, and this is reading in combination the statutes with the regulations, with the parole board policies. And as this court knows, the court.
You talk, I've been listening to you for 20 years or 10 years. You talk so fast. And this is really important. Could you slow this down?
Of course.
Tell me what the limitation is, because I want to note it.
Right. So if it's a violation of the actual, if the board finds this is an actual violation of the person's, say, home plan, then their actual plan for their medical parole. And if the board, and there is some discretion, I would say.
So it's limited to violations of home plan? Is that what you're saying the rule is?
Or a significant violation of their medical parole. I don't know if there is, I would say there is some discretion built in. There is some, if you.
But we should read the word significant into the statute?
No, I mean, the parole board is definitely taking a cautious common sense view here and not taking the view that any minor infraction is going to amount to a considered a violation enough to revoke parole. And I think that's important, and I think that should factor in to why this statute.
So, but is it a significant violation that merits re-imprisonment, or is it just a significant violation? I'm just trying to understand what you interpret the statute to require.
A violation that would warrant revocation of their parole, a violation that would be significant enough that it would, so first of all, before it ever gets to the parole board, before it ever gets to that point, the parole officer, in consultation with a parole officer, makes a determination here, the field parole officer makes a determination that this is a violation to go forward on revocation proceedings.
But again, and I don't mean to belabor this, I know it's going over, but their argument is that you have to have a second part. You can't just decide there's a violation. Rather, it needs to be a violation that warrants re-imprisonment. It sounds like you agree with that their violations need to warrant re-imprisonment to be found.
I think that's right, Your Honor. I think my disagreement, the parole board's disagreement here is that the board doesn't have discretion to consider extraneous factors, like whether they themselves, here the court is specifically in Emma, and this is a suggestion I think my sister is making for all cases, is that even when there is this significant violation of medical parole, the parole board found that here it's a violation of his home plan. It's one of the key reasons why, one of the reasons, at least, that he was allowed out on medical parole is that he was going to comply with this plan. He did not comply with it. That is a serious violation. What my sister is asking for is not that a finding of that has to be that kind of violation. If that was the case, there would be no appeal here in Emma's case, because he certainly violated an important part. This wasn't a mere technical violation. My sister's argument, and I think what the parole board is disputing, is that there has to be an entirely different second step, which is, in a sense, what is allowed in discretionary parole. And that's saying, look, there's this violation, serious violation, it warrants revocation, but we don't care about that because we think there are other outside mitigating circumstances that have nothing to do with this violation. They don't excuse this violation. They don't justify this violation. That is a basis for granting him medical parole. That is essentially taking away the authority of the commissioner of the DOC. That is within her discretion. And whatever we call this, whether we call it re-parole or whether we call it re-release, whatever we call it, it's the same thing. What my sister is asking for is that we take into consider, the parole board gets to consider outside considerations that have nothing to do with the violation and say, should this person go back to prison or not? But that is not what the statute stands for, and there's no due process right to that. There's no due process right to that in Morrissey. We can't read into, court shouldn't read into a due process right for that. So there is that, certainly the prisoner is entitled or can be entitled to consideration of that on a new petition, but he's not entitled to that.
Thank you so much.
I'm sorry, yes, I know.
We're going to wrap it up here.
Yes.
And I'll just ask Attorney O'Donnell if Attorney Johnston has covered it for you.
Well, good morning.
I'm joking. Go ahead.
Ted O'Donnell, the Commissioner of Corrections. I'll address the second question that was reported by the single justice. And the question was, does the commissioner have the ability to, and I'll use the word re-parole, someone that has been returned and revoked on a medical parole? And if so, what's the process that's followed for an individual in that circumstance? As you may have gathered so far, certainly from within the brief, certainly the commissioner has the ability to consider another medical parole petition on someone that's returned for this type of a matter. You heard Attorney Johnston mention there are 6. So 4, the other question referred by the single justice was, of parolees who had been revoked, how many have put in another request for a medical parole, and what was the outcome? So 4 of the folks that were returned into the prison, of them, 3 had filed a new medical parole petition. And in none of those cases did the commissioner assert that she was unable to consider the matter because she was prohibited or something like that. In each of the 3 cases, she denied the new medical parole petition for substantive reasons, public safety reasons. The 4th individual, he had started to put in a medical parole petition, but then his regular parole date came up, and so he withdrew it, and he got released on regular parole. There were 2 individuals whose medical conditions improved while out on parole, such that they were deemed to be no longer eligible, so they returned to the DOC, and they haven't as yet put in a medical parole petition. The process is the exact same that's followed for an initial medical parole petition. So an individual submits a petition to the superintendent of the facility.
Can I stop you there, counsel? When can that petition be submitted?
They can file at any time, Your Honor. It does make sense, though, to focus on this context. If you have an alleged revocation pending, it's, you can file it as soon as you come in. But I know the commissioner is going to want to know, was that an established fact, whatever was alleged? It really doesn't make sense. I know Mr. Emma filed it beforehand, and he got revoked formally on February 10th. His medical parole petition was denied by the commissioner on March 29th. So that's not 66 days, that's shorter. But it's not really a practical approach to take, I would suggest, for the individual to immediately refile. Because the commission is going to want to know, is that an established fact? Whatever was alleged, whatever caused the person to come back, that's going to be a factor. The reason that the commissioner should
The reason
be
I ask
making-
is because your opposing counsel seems to be taking the position that 126 days in the context of a terminally ill patient prisoner is a due process violation. And so if there's no gating issue, that somebody can file a petition for re-release or re-parole as soon as they enter the revocation process, then the 126 days gets shortened.
They certainly can, and every situation's different and unique. Not everybody that gets granted a medical parole is terminally ill. Some are. The key point is, and it's a public safety matter, for someone to be released on medical parole, the commissioner is persuaded that they're so debilitated that their release, they can be expected to remain at liberty, not violate the law. There's no public safety aspect at risk. So every case is different. So if you have a person returned, he could immediately file, the case could immediately be looked at, and the commissioner, can immediately rule. She doesn't have to take the 66 days, but that is usually probably what's going to happen, because she wants to know, has the alleged parole reasoning for return, has that been formally adjudicated? Yeah, he's revoked. This is what we determined that he did. Now that's going to be a factor in play in the commissioner's decision-making, because that fairly might call into question, how debilitated is he now? Maybe he's improved to some respect if he's able to, like in Mr. Emma's case, and I know there appears to be some factual dispute as to, but clearly his place of residence, he was terminated. So here you have a guy that requires medical attention, terminated from his assigned placement. Where else but in a correctional facility is he going to get medical care in the immediate term? So, I mean, it makes sense. But so he comes back in, the commissioner certainly can and does look at any new medical parole petition submitted, and basically that's that. Are there any other questions? I have a small part to play. It's mostly the parole board's case.
Okay, thank you very much.
Thank you, Your Honor.
Court all rise. Hearing. Persons having anything further to do for the Honorable, the Justices of the Supreme Judicial Court, now sitting at Boston within and for the Commonwealth. I turn to the court. The sitting of this court is now adjourned. Why take the Commonwealth of Massachusetts?